Good morning, friends. Today I was thinking about going to the fundamentals in the Companies Act, particularly with respect to the Memorandum of Association of the company and Objects Clause of the company. It has been now almost, we can say, 6 years, 2013 Act, effectively from 2014. 6 years have gone already, ever since the coming into force of the Companies Act 2013. We have come to May 2020, which means more than 6 years have gone between 14 to 2020. Look at the position of the Memorandum of Association with a specific purpose of looking at the objects clause of the Memorandum of Association and the provisions, rules connected thereto. You must be aware that there is a provision called section 4, which is the main section with respect to Memorandum of Association. In section 4, you will be seeing what are the various conditions to be contained in the Memorandum of Association of the company. If some of you are familiar with the 1956 Act, you must be able to remember section 13(1). Look at section 4, particularly subsection 6. It says the memorandum of a company shall be in respective forms specified in tables A, B, C, D and E of schedule 1 as may be applicable to such company. So for example, if a company is a company with share capital, you will apply the table A. Now, keeping this particular requirement of subsection 4 of section 4, subsection 6 of section 4 in mind, kindly look at section 13. If you come to Companies Act section 13, you must be aware section 13 is about alteration of Memorandum of Association. There are specific clauses: capital clause, registered office clause, objects clause, and liability clause, and so on. Name clause, it's another clause. So these of all these things, there is a omnibus requirement which is provided in section 13(1), which says the memorandum of a company by special resolution can be altered. So you must require a special resolution for the purpose of altering the Memorandum of Association. As I said, we are concerned about objects clause. When you see objects clause, I have already said subsection 6 of section 4 talks about objects clause shall be the memorandum of a company shall be in schedule whatever A, B, C, D, E which is applicable in table. Okay, so you can table A you can apply if it is a company with share capital. Now, keeping that in mind, look at section 13, particularly come to the section 13(6), which says any special resolution for altering the Memorandum of Association of a company must be filed with the Registrar of Companies, and any change in name, of course, alterations, central government approval and all required. So therefore, there is a requirement for filing with the registrar any special resolution altering the Memorandum of Association of a company. Then you go to section 13, particularly with respect to objects 9. Section 13(9) also is a special provision which says the registrar shall register any alteration of the memorandum with respect to objects of the company and certify the registration within a period of 30 days from the date of filing of the special resolution in accordance with the clause 6 within brackets A. So subsection 6A what says? It is you file the special resolution and it says you must file it with the registrar, and it says the registrar shall register the alteration within a period of 30 days from the date of filing of the special resolution. So the journey is from the date of filing of special resolution, another 30 days it must be registered. Then there is a provision called section 13 subsection 10 which says no alteration made under this section shall have any effect until it has been registered in accordance with the provisions of this section. So therefore, there is a registration requirement. So filing, registration, and registration must be done within 30 days, and if it is not done, it shall not have any effect until it has been registered in accordance with the provisions of this section 1310. But specifically there are some provisions like section 13.8, which says a company which has raised money from public through prospectus and still has unutilized amount out of the money so raised shall not change its objects for which it raised the money through prospectus unless a special resolution is filed passed by the company with so many details and public notices and all. You also may have to read rule number 32 of the company's incorporation rules for the purpose of understanding the requirements which are specific. For example, this is about a company which has raised money from public. Number one. Number two, there may be unutilized amount so raised, and that money should have been raised for a particular object. That object specified in section 13 within brackets 8 is different. It is not talking about main objects and all. It is talking about the objective of the public issue. I raise the money through the capital I have raised through the public issue or whatever it is through prospectus for a specific business purposes. So that is called the object within the meaning of section 13.8 read with rule 32. So if I have raised money, if a company has raised money through prospectus for a particular project, for funding particular business vertical or whatever it is, and there are let us say the unutilized amount is there, and now the company, such a company wants to alter the objects to pursue something else or something, then they have to follow this 13.8, which is a special provision read with the rule 32, where there are various things which are required to be explained and all is given. So basically we are talking about a general provision relating to alteration of articles of association, which is contained in section 13.1, a general provision contained in section 13.6 for filing the resolution, a general provision contained in section 13.9 for registration of the resolution, alteration of the memorandum, particularly object class, and a general provision which talks about 13.10, which says no alteration shall be valid, shall have any effect until it has been registered. In addition to this general provision is the special provision with respect to a specific company which has raised money through prospectus for the purpose of pursuing a particular object, and it has unutilized amount, and when there are unutilized amounts it wants to alter the objects. Keeping in mind this, if you look at the difference between 1956 Act section 13, particularly section 13.1 of the 1956 Act clause D, which was containing two subclauses. Clause D of section 13.1 contained two subclauses, 1956 Act. First subclause was saying the memorandum shall contain the main objects as well as incidental and ancillary objects. Clause 2 of section 13.1D was saying other objects. Therefore, the question that has arisen recently is, in one of the cases, is that when there are other objects specified in the company, which is an existing company prior to the coming into force of the Companies Act 2013, whether a company can pursue anything specified under the, anything listed under the other objects clause. What will be the provision? If you look at the entire Companies Act 2013, there is no provision with respect to such type of matters. Nothing has been stated that if a company is an existing company and it wants to pursue anything listed under other objects, it has to do this, it cannot do that and all. Under the 1956 Act, of course, you had that 149.2a. 149.2a was a specific provision wherein we used to argue in courts, we used to speak about it, where the beautiful language of business not germane to the business which is carried on is deemed to be the new business for the purpose of 149.2a. Those things they are things of the past. Today we don't have any provision. If a company has other objects in its memorandum and it is not a company which has raised money for the purpose of pursuing a particular object with unutilized amounts remaining, there is nothing which is practically blocking the company from pursuing anything stated under other objects. It is as good as the objects, because even if you read section 13 of the 1956 Act, it says other objects which the company intends to pursue. Therefore, the shareholders and the general public are aware the company is having following set of main objects and it wants to pursue other objects also. So that is how it is there. Stopping for a minute, you go back to subsection 6 of section 4, it says memorandum of a company shall be in respective forms. Let us take table A, company with a share capital. The memorandum of a company shall be in respective form. But the word company itself is a defined word. And if you see the definition clause in section 2, company, section 2 within brackets 20, company means a company incorporated under this act or under any previous company law. So therefore, company incorporated in previous company law is also a definition. Previous company law is also defined. It says it includes Companies Act 1956. So previous company law, a company incorporated under previous company law is a company, and section 4 subsection 6 says the company shall ensure that its memorandum is in a particular form which is in table A. This does not really suggest that you must align your memorandum to table A if you are a company which is incorporated under the 1956 Act or even before 1965. If you see section 13, there is a reference, because those days they used to list everything. In fact, I remember LCB Gover, learned company law author, was saying that a company, the way in which the Companies Act enables them to pursue objects, may provide for a gold mining company may be able to provide for a fish fry shop also as part of its objects. So there are a lot of such things happening. So basically, if a company pursues, if an existing company pursues something which is listed under object class, there is no provision like 149(2)(a. There is no provision which says objects have to be like this, it should be done or it should not be done and all, except what we saw in section 13(1) or specifically with respect to section 13(8) companies. So generally speaking, there is no provision. You can't say that there is a prosecutable offense. But as a matter of governance and all, we have to see. And probably if you look at very, very strictly and interpret the provisions of subsection 6 of section 4, it appears to say the company shall, the memorandum of a company shall be in respective forms specified in table A. If you go to table A, you read clause 3, it contains only main objects in clause A and the incidental objects. I am reading for your benefit table A. Table A is saying like this only. If you see the clause number 3, it says clause A, 3A, objects to be pursued by the company on its incorporation. 3B, matters which are furtherance, matters which are necessary for the furtherance of the objects specified. There is nothing called other objects here. They don't speak about incidental, ancillary and all. Clause 3B of table A says matters which are necessary for furtherance of the objects specified in clause 3A, which are main objects. Therefore, the new Companies Act provides only for main objects, and certain powers can be added for the purpose of furtherance of the objects specified in main objects. So this is the legal position. So I thought that we will revisit the fundamentals of the Companies Act, particularly with respect to objects clause of the Memorandum of Association of a company. Any company incorporated under the 2013 Act, this problem won't arise. However, we always look at the 1956 Act, a lot of companies are existing and pursuing their objects, continuing to be in operation, doing business in the current era, even though they were companies incorporated under any previous company law. Thank you very much.